Four Yukon First Nations have been granted intervenor status in a Supreme Court of Canada case. The case challenges Ontario legislation that fast-tracked redevelopment of a closed theme park called Ontario Place. The legislation shields the province from legal challenges. The Yukon First Nations say the territory used similar tactics while making changes to the Health Authority Act. The court case could set a precedent for public trusts nationwide. Dhir joins us now from Whitehorse with more. So TJ, what's the connection between this case and the Yukon?
Well, it has to do with legislation passed by the Ontario and Yukon governments. When Ontario passed legislation to fast-track the redevelopment of Ontario Place, which has been closed since 2012, the government wrote into the legislation protection against any legal action towards the redevelopment. Redeveloping the land the theme park sits on has been a contentious issue, especially as this legislation lets the province bypass environmental and heritage protections. Two appeals in Lower Ontario courts failed before winding up before the highest court in the land, the Supreme Court of Canada. And the basis of the case is the legal protections the province gave itself. Those legal protections are similar to the ones the Yukon government wrote earlier this year into a bill to change the Health Authority Act. Yukon First Nations have been up in arms about the Health Authority since the new government implemented its changes in the spring sitting of the legislature. The four First Nations involved are Nachonayak Dun, Little Salmon Carmacks, Selkirk, and Vuntut-Gwitchin. They've been approved as interveners in the case, but so has the Yukon government.
So what arguments do the First Nations and Yukon government bring to this case, TJ?
Well, it's important to mention that as interveners, they're not a party to the case, but their interest has been deemed sufficient enough to let them present their arguments before the court. There's a lot of interveners in this case: Greenpeace Canada, the Canadian Constitution Foundation, two Alberta First Nations, four other provincial governments, and the federal government. And that's not even the full list. The Yukon First Nations say the protections both governments gave themselves are unconstitutional. For its part, the Yukon says it needs those legal protections. It says a ruling against Ontario could undermine the public trust framework here in the Yukon. The Supreme Court told CBC News the case is scheduled to be heard on October 15th.
Can you explain that public trust framework for us, TJ?
Yeah, definitely. So the Yukon government is legally defined as the trustee of natural resources, as outlined in the Environment Act. If Yukoners feel those resources are threatened, they can take the government to court. Now, going back to the case before the Supreme Court of Canada, the proposed health authority was also designed to be in the public trust. But again, like Ontario, the Yukon government protected itself against any legal action when it changed the Health Authority Act in the spring. The Ontario group that's been fighting the case since the beginning hopes the Supreme Court creates a precedent for public trusts nationally that would prevent governments from bypassing the public interest. The Yukon government says that unless the Supreme Court specifically states to leave the territory's rules alone, it could mess up the rules that are already written here. Megan?
Okay, TJ, thank you so much for that.
You're welcome.